Welcome to the monthly Truck Stop webinars brought to you by the Motor Carriers Insurance Education Foundation. These truck stops are presented the second Thursday of each month at 2 p.m. Eastern Time. These webinars are open to members of the Motor Carriers Insurance Education Foundation and their insureds. These webinars are presented as an industry update for information purposes only and do not qualify for state CE credit. If you're seeking CE credits, you need to visit our website, MCIEF.org, or email trs@mcief.org, and we will tell you about the 12 hours of CE we also furnished each year. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar by email. If you experience audio problems, please send us a note in the chat window of the call or call 800-741-4084. We will attempt to correct the problems as soon as possible. The Drug House Clearinghouse. We've been talking about this for a long time, but based on what we find out, the information is public and it's going to happen this year. It's a big part of what we need to look at as the insurance industry is our insurers meeting these requirements for a couple reasons. One is obviously to get the impaired people out of our units, but more important, are we meeting all these requirements in our hiring and our post-crash so that when we deal with the plaintiff's attorneys, there's not some missing part of this. So as always, I call my friend out of Phoenix, Rich Bren, who introduced me to Gina. We visited a couple weeks ago in Phoenix when we were doing the programs out there. And Rich has lined this program up for us. Rich, welcome today, and will you take it from here, my friend?
Yes, sir. Thank you, Tommy. And hello, fellow MCIEF members. We've had the opportunity to explore this topic in the past and talk about what's coming down the pike. And we're very happy today to have Gina back with us. Gina Kesler is the CEO of Impact Employee Solutions. Her company, which I'll call IES, is a national provider of uniquely tailored employment screening solutions. This includes drug and alcohol testing, background checks, drug-free workplace policy, program management, and compliance consulting. Gina is a founding board member of the National Drug and Alcohol Screening Association, which is referred to as the NDASA. Gina provides the thought leadership that makes both her company and NDASA industry leaders for providing advice, resources, and services to employers. She's been leading the charge to maintain safe and drug-free workplaces. With her expertise in the DOT-regulated industries, Gina combines her work with the NDASA and her company to provide an industry voice directly with the agencies such as the DEA, the DOT, the Office of Drugs and Alcohol Policy and Compliance, another acronym for you, ODAPC, and cutting-edge information for employers in transportation and other safety-sensitive positions. Gina speaks on a regular basis, and she's gained attention to key policymakers, people like Dr. William J. Bennett, the former drug czar who was under the George H.W. Bush administration, worked with her to advance the importance of preserving an employer's rights for drug-free workplaces. So her company, IES, is a consortium, a third-party administrator, and a consumer reporting agency, which provides a necessary balance of screening services and consultation while reducing risk and exposure for employers all under one roof. So keep that in mind as we go through this today, because some of those things are fundamental for you to understand if you're a motor carrier listening, as well as any of you who are helping them in this area. So we at the MCIEF, we've learned from Gina in the past with the webinar that she's participated in, and I've personally seen her take action in our state, in Arizona, when some very liberal bills have been introduced about legalization of marijuana, and they were going to have a very negative impact on safety in our public and the employer's ability to maintain a safe workplace. So she has great insight. This is a very difficult topic. There's going to be a lot of tension between public safety, regulatory compliance, personal privacy rights, and the appropriate employment administration. So get ready to take some notes today. We're headed into some chaos thanks to a new government implementation of this clearinghouse. So don't shoot the messenger. You know, we've all heard Tommy say, blame it on the government. Well, we're back into that cycle again. So get ready. The roller coaster is going to take off. So buckle up. Gina, I'm going to let you take it from here and give us some insight. So ladies and gentlemen, Gina Kesler.
Thank you very much, Bren. Rich, that was an incredible topic and segue into what I would normally not call a roller coaster yet, but I think that it might be appropriate come about February when this whole thing crashes in the website. So we'll see if it doesn't rival the Affordable Care Act website that we saw a couple of years ago that bombed out. So anyway, I appreciate your time. Thanks for inviting me back. Thanks for everybody that's attending this webinar today. A couple things I just wanted to mention before I move forward relative to the National Drug and Alcohol Screening Association. We're a bunch of industry veterans in this space that got kind of sick and tired of our existing associations, mainly around the fact that there was just no rights and policies and voice that would advocate for the employer. So we started our own that launched back in April of 2018. And it's critical to note that and how important it is for employers to have resources and access to associations that are really that have your back and that are on your side, because that truly is our mission, is to advocate for safe and drug-free workplaces and communities. And we're going to do that through legislative advocacy, education, training, and excellence in drug and alcohol screening services. Now, as we go along and through a little bit of the details with the Clearinghouse, this also becomes self-evident in terms of our ability to align positively with the federal government. And while the Office on Drug and Alcohol Policy and Compliance, which is the governing agency that maintains and writes 49 CFR Part 40, that's your federal drug and alcohol testing program, they're not allowed, obviously, because they're a federal agency, to be exclusive with any one party or association or whatnot. However, because there's 3 of us in the industry and one of us is choosing to take charge, they have basically asked us to partner with them from the standpoint of educating the public, educating service agents such as yourself, and educating employers on the Clearinghouse and what's happening with it, and the fact that it's actually going to start. So we're going to go through a timeline really quickly here in the next few slides that you may have already seen from other publications, or you might remember from a couple of years ago, but just as a summary. But it's important to note that while our mission through NDASA, which also closely aligns with my own mission of IES, which is to impact, deliver information that impacts lives. Everybody's got to get a job, and everybody might lose a job. So our information that we deliver is very important. The ODAPSI mission is also to ensure the nation has the safest, most efficient, and modern transportation system in the world. It's much longer than that, but that's key and critical to know, because the Clearinghouse, albeit will be a big game changer and will cause issues along the way, as anything else does that rolls out from the government. Keep in mind, please, that the whole theory behind it is to improve highway and public safety. So that's probably the one main reason that I stay positive about another government rule and regulation enforced on us, is simply because we have a duty to maintain safety in our public, on our public highways, in our communities, on our roadways, in our air, on railroad, all of those things. And so that's exactly what this is intended to do. So eventually we'll work out the kinks. I am very optimistic about that. Everything does work out in the long run, and it all points towards safety. So with that, a couple of areas that it intends to do. It does intend to make it much harder for drivers to conceal any of their drug and alcohol problems, especially those that might go from employer to employer to employer trying to pass a pre-employment drug screen, and once they do finally pass it, they're hired and they go back to doing what they're doing. Because the Clearinghouse is intended to sort of warehouse this data, it's also intended to stop that kind of activity and that kind of behavior from continuing, which I think probably answers one of the biggest problems that we've been seeing over the last 10 years as substance abuse has been on the rise. It's also intended to provide inspectors and law enforcement the means to ensure that these drivers, should they have a violation, that they are going through the required evaluation and they complete their treatment before they're coming back to perform those safety sensitive functions. And then finally, the big brother part, which we don't like, but it is critical, is a way for employers to have an easier way to conduct pre-employment investigations and their reporting requirements, as well as for the FMCSA to follow up with employers and make sure that they're in full compliance with with not only the Part 382, the testing part, but also the investigation portion, which will be the database, and the necessary reporting requirements. So to try and continue to put a positive spin on this craziness, it is all about safety in the roadways. And we all want to be able to get into our cars with our babies in our front seats and drive down the road and not get mowed over by a big truck. So that's the whole point of this. So with that, there's more details to come in terms of how this is going to happen. And I will tell you, there's going to be a million questions that are still yet to be answered. I'm going to provide what little I do know, what little I've been able to get directly from a couple of the gals at FMCSA in Washington that are doing their sort of travels to educate the public. But there are a lot of questions that we posed that they just couldn't answer. So more will be to come, and hopefully I'll get invited back as we get closer or get into November and December, because I think we'll have a lot more that we can add to this at that point.
Gina,
yeah.
just note, we are already planning, and Gina's already agreed to come back in that time frame, November, when we're closer to it. But the thing that Rich and I wanted to start earlier is to make you as a retail agent aware of what's happening, so that it won't be, your insured will be prepared for this. And also, as we always talk about the foundation, to be added value to your client. In other words, provide more than the policy. This is going to be something they're going to have to struggle with, and unless they have advisors like Gina and hopefully your agents now knowing more about this, they'll be caught blind about this. So that's our point now. Let's start warning them now, so when it happens, they'll be prepared and make it a smooth transition.
Yeah, definitely, and thank you. Yes, the whole point is we got to start talking about it now. It can't be a shock come November when registrations are open. So improving highway and public safety, just a little bit more on this. The clearinghouse will require both prospective employers and current employers of their employees to query the database looking for alcohol and drug violations. We'll get into more of that. It's also critical for you to know that state driver license agencies will be required to query the database as well anytime there's a shift or change or movement with an active CDL. They have to ensure that nothing has been reported in before they make any of these changes. And there's also a two-way reporting in that motor carrier will also report back to state driver's licenses in certain situations, which we'll cover later on. And then lastly, the other governing body that can have some limited access into the database is the National Transportation Safety Board. Now, NHTSA is only allowed to access relative to an investigation of a crash, but the amount of information they have access to is incredibly limited, and we'll get into a little bit of the confidentiality and protections of this information as well. So that gives you kind of an idea of who, of the governing bodies and the types of individuals that will be accessing this database and why. So from a timeline perspective, and again, this might be a little bit redundant as you've heard this over the years, 2016, December 5th is when the rule became final. It was around 2014 when it went out for public comment, not only for 30, but it extended out to 60 days. So the rule became final. Obviously, it wasn't enforced just yet because there was no database, but it does impact anybody driving trucks that exceed 26,001 pounds, such as school bus drivers, heavy hauling equipment, public works, construction workers, bus drivers, anything with 16 or more seats in general fall under this. So those that are impacted and must follow Part 382, the federal drug and alcohol testing for motor carrier, is also impacted and required to follow the clearinghouse as well. Now, fast forward to November of 2019. This is, we have yet to get the actual date, but this is the go live date for registrations to occur. And so it will be encouraged that employers, medical review officers, substance abuse professionals, third-party administrators, state driver's license agencies, the various service agents will then be asked to register into the portal, including drivers, individual drivers. They are going to be required and asked by the honor system to also register into the database so that we are prepared and have information that will start as enforcement begins January 6th of 2020.
Gina, when you register, is that just going in and making an application, what, with their driver's license number and that stuff? And again,
Yep.
because as you move here, the thing that I want everybody to listen to be aware of, the thing that hit Rich and I when we were talking to Gina in Phoenix, is that they've got to start registering in November, because if they wait until January and they aren't already registered, they might become unemployable for a period of time. Gina,
Yes.
Isn't that the downside to that?
Yes, that's a very high probability. And so exactly what needs to be put into the database, I've got a full slide on that, so stay tuned.
Okay, no problem. I just want to make sure that's why this urgency is there, this registration process. This is why we're going to, again, visit it again in November, when maybe we got more specific time and, you know, how to really do it. But we need to warn people about it now. Thank you. Okay.
No problem. So 2020, be prepared. January 6th is really go time for the database. Employers must be running queries, MROs must be accessing it, and it's enforced. Enforcement simply means if you're not doing it, there's going to be fines associated with this. So we're going to go into more detail there. And then finally, for those of you that are familiar with 391.223E, that is the requirement for employers to be soliciting for previous employer information for drug and alcohol violations. That is actually going to maintain itself for 3 years. So there's actually going to be, the employer is stuck with 2 processes, not one, for the period of 3 years, or until approximately December 6th of 2023, when they feel that that 3-year time span will be enough time for the database to have grown on its own and have enough data in the database, and allowing an employer that's already registered to stop the manual process of the previous employer checks that we have to do right now. So we'll get into that in more future slides as well. So that's kind of timeline that we're at with all of this. So, few things that there's a long laundry list of what's going to go into this database. So I've picked out really the top items that we know are going to be repetitive and entered into these databases. So violations are the primary entry. There's not all, but primary entry, such as anybody reporting for or remaining on duty that has an alcohol concentration of 0.04 or greater is one example. If you're using alcohol while performing or within 4 hours of your shift, and you have knowledge of that as an employer, has to be reported, that's one example. If you use alcohol within the 8 hours of a post-accident test that hasn't been completely wrapped up and finished off, and there's knowledge of it, it has to be reported. That's one example. If anytime you test positive for any of the 5 DOT drugs, verified positive by the MRO, that goes into the database. If you refuse to take a drug or alcohol test, that has to go into the database. So and then there's probably 16 to 20 other items that could potentially going into the database. So those are just examples of what we mean by violations, and I'll hit on a couple more that stand out here in the next few slides as well. From an employer's requirement perspective, this is where your clients, are going to have some work to do. So unfortunately, while all in the name of public safety requires work, and so I'm going to talk to you about service agents, but more importantly, for your insureds and the employers, and maybe even for yourself, if you're named as somebody that can help your employers provide the administration piece to the database. Every new hire that's going to be driving a truck that qualifies for federal drug and alcohol testing, the employer must run a full query, and prior to that must have driver consent. Now, ironically, if you can't get driver consent, they don't get to come to work for you. So we've got a little push-pull here as we go through this. And also keep in mind too, for all this additional administrative work that's going to be placed on employers and service agents to fulfill the requirements of this subpart G, expect prices and fees and costs to go up. Not just worth of your time, but additional fees and costs will likely go up as we anticipate because of the additional work. Annual limited queries are also required. So for those of you that have all of your drivers that are already part of your workforce and this rolls out, they're not saying you have to go now do a full pre-employment query because they're already employed by you, but you will have to run an annual limited query and still get their consent before running so. Now, interestingly, these limited queries don't show you all information as an employer. So the employers are going to pay for an annual limited query to ensure that no violations have been entered into the database. If there is some sort of violation, you won't know what it is through the limited query until you pay for a second full query within 24 hours of that limited query being run that will then show you what the violations are inside the database. So this is going to cause a lot of pushback because there's costs doing business with all of this. I don't know for sure what those costs are. It's been rumored anywhere from $15 to $16 per full query and about $10 for a limited query. So keep that in mind too, because we're talking about additional costs back to the employer. If 24 hours pass, the driver and for whatever reason you're not able, the employer is not able to run that full query after the limited query shows something has been entered, the driver must cease to perform safety sensitive functions. Again, another management piece that the employer has to pay attention to. There could be a variety of reasons why it doesn't get done, right? You got one person assigned to do this and you didn't know, and all of a sudden it comes back that they went on vacation and they didn't run the full query. Technically speaking, that driver needs to be yanked. So, and keep in mind that whenever you run these limited queries, government knows it. 24 hours later goes by, if you don't run the full query, government knows it. So there's going to be flags along the way at some point to capture some of this missing or time lapse, as it will, that could cause issues for employer as well as driver. How fun does that sound so far? I'm only in just like slide 4.
Yeah, well, I see more paperwork. I made a comment earlier, and Rich heard me say this, that my father was a very smart man, but he was lacked in a lot of technical education. But clearly this stuff is getting to a level that they have to be aware of this. It's going to be a real problem, Gina, for most of the smaller motor carriers, because you're talking about someone with 2 trucks who have to meet this requirement.
Absolutely.
If they hire any driver, even if that driver is their brother-in-law, you know, and the key part that concerns me is until we publish this and other people are, how many people are going to be aware to do this? So they get ready to hire a driver and all of a sudden the driver's not hireable. That's going to be January is going to be interesting, 2020. So you hang in there because we might call you on a repeating basis.
I'll get the bat phone that's 24 hours just for you guys. Okay, so here's
yet another system to learn how to use, right? And you're dinging the bell. I mean, I'm listening to you ring the bell every time you do a query. So
I know, seriously.
Sorry, go ahead.
No, that's fine. So we just kind of talked about a little bit of the negative stuff where, you know, if there's a hit, so to speak, this is my background check language coming in. If there's a hit on on the query, on a background query, which states that whether it's full or limited, you know, we know now that you've got to move within 24 hours, see what the full query says, and you likely have to pull that driver off anyway because there is a violation reported. Here are a couple of instances where that wouldn't occur, where the driver can continue to perform safety sensitive duties based on a change made in the query. Anytime a successful completion of a substance abuse program, professional program, has to be reported, or a negative return to duty test result, that would be reported. Or if they have completed the follow-up testing plan that's part of that SAP program, that would be reported. and then just, you know, full completion of any of that. So anywhere along the way, if a driver is going through substance abuse professional program and there are updates made, that's going to create quote unquote a hit on that limited query that will require them to run a full query. And if the employer sees any of these two items there, that's all they're seeing. The driver is fulfilling their obligation or on the path to, and they can in fact continue to drive. Obviously, it would change if a positive follow-up test were entered or something like that. Then it's game off and they got to stop driving. So those are the two instances.
Gina, how many motor carriers, and Rich, you appreciate you putting things, actually go through a driver who has failed the test without just firing them and not going through this? I mean, you know, this becomes a gray area. Then it also becomes a legal question that if we now allow them back and for some reason they fall off the wagon and have a crash, then as an insurance provider, I see dollar signs there.
You'll always see dollar signs if there's a crash.
Well, you know what I'm saying.
Now that said, you know, there's a component that we must be careful from a legal perspective around the dignity of a driver that has gone through a substance abuse program. If they have completed a program and that those details are then removed, which you'll see in a later slide, they've done what they were asked to do. If they all of a sudden, you know, decide to drink and drive again, or they come back and they've got drugs in their system and they do crash, you know, that's a whole new event. And there's nothing in the regulation that says, oh, you completed a SAP program, but you fell off the wagon and now you're done. That's not the case. They would have to start all over again and go get their evaluation from the substance abuse professional. Wow. So it doesn't, yeah, I mean, you can't predict or control what a driver might do. The hope of it is, though, that they've got evaluated in treatment, that they don't do that and they don't repeat. And that would be the hope, obviously. But part of the challenge we've had so far is we've had no mechanism to effectively track this. And that's what we, that's
who's paying for the SAP, Gina?
I'm sorry?
Who's paying for the SAP?
Generally speaking, the driver does. Not always. But it's a complete, that is a policy question that's decided by the employer, not a requirement. So generally we see the employee, the driver must pay for that process. Because if they don't get to keep their CDL. So those that are lifelong drivers that want to maintain a CDL, they have an investment in that. They're more likely to go through the process on their own and get it done. An employer, by the way, doesn't have to keep somebody that tests positive. They can remove them from employment and they can terminate them. It doesn't preclude the CDL driver from finishing the process if they want to keep their CDL active. They will have to go through that. So that's really kind of off. I don't want to get off too far off topic, but because this database is all it's doing is now reporting on a process that's already been in place for a while. We just could never see it. Lastly, the employers are required to retain records of all of these queries, both limited and full queries, for 3 years, or until that January 6th of 03 or 23 hits, where a valid registration into the database will suffice and we won't have to keep all these queries, you know, separately on paper, because the previous employer thing will also have been able to stop. So. Okay, so we talked about reporting into the clearinghouse, and this is, I'll apologize up front, I made a mistake here in that I mentioned in the previous slide or excuse me, no, I'm sorry, I'm thinking about, I have a slide after this that talks about service agents. That's where the medical review officer should have gone into that slide, but it made it into here. So we all know that the employer must report into the clearinghouse if they learn of information such as below, a negative return to duty test came back, or somebody refused to take a drug or alcohol test, or anything like that, the employer is required to report into that database 3 business days after they receive that information. So again, yet another sort of timeline that they've got to keep in the back of their head, in the back of their mind. And if they don't make that, I'm sure it'll be some sort of flag at audit time, but they've got 3 business days. Now, the medical review officer, who is the service agent and required part of the process, is also required to report into the database on behalf of any drug test that comes through 2 business days, within 2 business days of making a determination or a verification. Now, what that means is a verified positive drug test that they'll, within 2 days, have to include that information into the database. As far as the determination, that could be where they determine the test came through and it's determined to be a refusal to test. If the driver has tried to substitute their sample or adulterate their sample, they'll cancel the test out and call it a refusal. So that's what a determination means. So there's a couple different ways that the MRO has to look at this. If it's anything other than a negative or something happened to the sample in transition that had nothing to do with the driver, they have 2 business days to enter that. So there's a lot of players touching this database. There's a lot of information the labs also have to enter. We just don't know the extent yet what. I don't have that data yet, but the MROs will likely be chasing information. They're going to likely go to the employer or the third-party administrator for it, which again, like I mentioned in the earlier slides, expect costs to increase because there's a lot of extra items that are now required that may not make it into the paperwork at the time of collection by the time the MRO receives it.
Gina, I also see some liability in their position in that case, because if they don't do it and later it's found out about it, that's going to cost money in a court case.
Definitely.
You know?
And when you say they don't,
I'm talking about the reporting, the people who should have reported the failed or refused test, and then for some reason didn't do it right, and then later they found out that there was that. And plaintiff's attorneys always tend to find out everything. So what happens? Yep. I could see some additional liability involved in that situation.
Well, I'm glad you said that, because that is a perfect segue into this slide.
Oh, good. All right, I'm ready to do that. But I'm thinking from the insurance side, and our common area. Besides blame the attorneys, blame the government, always blame the lawyers too. So.
Yeah, they're all part and parcel. So yeah. We know that from a service agent perspective, an MRO must report in. Employers will also do this, and obviously it's going to become a lot of extra work. So the law does allow for them to designate access by a consortium or a third-party administrator to perform many of these duties for them.
That's you.
It's up to just like 382 and Part 40 says, though, it's up to the employer to ensure that they have fully vetted out any and all of the service agents they're going to be utilizing, because if the service agent makes a boo-boo, it's coming back ultimately on the employer, right? So right. If for some reason the TPA is not fully informed, they don't know what they're doing, and they fall out of compliance, that just means the employer fell out of compliance, and there's your audit and penalty and interest and other things like that could come up. So it's really important for employers to pay attention to who they're working with. It's important that they do work with somebody, by the way, and somebody you can't get away from, the labs, the MRO, they're required service agents of the process. But if you're going to work with a third-party administrator, and I'm going to get into that a little bit more in a couple slides later, okay. Just know that what they boo-boo on could come back to the employer, and that includes your anybody that's underwriting insurance. If there's a level of access that your clients afford you to get into for the clearinghouse, and you make a mistake, your client's going to pay for your mistake. So keep that top of mind. Here's another thing that's going to just draw tons of attention and be scary. Self-employed drivers, owner-operators, they have to designate a consortium or a third-party administrator to act as their agent, because not unlike the owner-operator that has to enter themselves into a random testing pool because they can't pull themselves on their own random test. It's the same mentality and idea with the database. So for anybody entering this space brand new and they get their DOT authority and they're ready to drive, even before they go take their pre-employment drug screen, they not only have to hire a consortium or a third-party administrator that would help administer the pre-employment and put them into a random testing pool, they are also needing to have that service agent or that TPA hit the clearinghouse for a full query and have that on file for audit purposes. So they don't get away from this, and that's going to be all kinds of challenging for those of us that have owner-operators in a big fat pool, because now we get to act as their service agent. So again, more liability, but I'm going to talk about that more later. Finally, substance abuse professionals also, they're certified, they're qualified, they're looked at, they're audited by the government for the purposes of what they do. So they also need to register into the portal and be able to report for any drivers that go through the return to duty process that they're managing. Now, that's everybody that goes, these are all the service agents and employers that go into the database, and they're reporting information into the database. But what about, where does the motor carrier come into play, right? Because obviously they're not going to sit back and be silent. So they do have a role in this in terms of notifying agencies and employers under these situations. So they will notify employers, they will notify drivers, consortium members, third-party administrators for the following. Anytime there's been an addition, a change, or a revision on a driver's record, or anytime that information has been released to an employer for any reason, the FMCSA is going to notify the driver by US mail, letting them know, okay? An employer did a background check on you, we're letting you know. Now, in theory, they should have consented for it. That's part of the reason that they notify them. Or there's been a change to your record, they're gonna let them know. They're also going to inform via US mail the state driver licensing agency for anything changed or listed or different within the clearinghouse. Because again, keep in mind, if you violate and this goes into the database, your CDL license becomes null and void until you go through a SAP program and complete it successfully. So the only way to really do that is you got to have your state driver's license agencies also piped into this whole process, both electronically as well as notification. And then finally, an employer, such as a prospective employer that runs a full query and finds nothing and brings the driver on and they're fully employed and driving, if within the first 30 days of that full query being run, there is some sort of change made to that driver's record in the clearinghouse, the motor carrier will notify the employer. After the 30 days, however, and ironically, if there's a change made, they will not. So I don't know what that means, but I guess it just means that you run that risk, and then when you run your annual limited queries as an employer, that's when you're going to find out if there's been additional or anything new or violations that they're recorded. Now, is this going to be perfect? Heck no, but this is sort of how they had it set up right now. So you asked earlier, what needs to be registered? There's a lot of information that needs to be registered, but this is the main stuff. Employers come November 2019 and thereafter must get in there and register all their contact information, DOT number, authorized persons enabled to enter the clearinghouse, and if they are working with a CTPA, they need to identify them. Other service agents, same thing. Your medical review officers and your substance abuse professionals must register, name, address, phone, and because they all have qualifying and certain certifications that must be up to date, not only do they enter all that data into the system for the first time, they also have to show evidence of those credentials, and then every time they re-up it, they have to continuously update the system. And then, of course, your consortium, third-party administrators, and any other service agent, perhaps the employer's insurance company, if they're running something on their behalf, would also need to register. Keep in mind the employer must name them, and then they can go in and put their company information as well as authorized persons. So for today, that's kind of the information required just to get registered and get started into the database. The hard part is, or the challenging part is going to be your drivers. Drivers must register themselves into the clearinghouse. They can look at their record at any given time for no charge. Unlike a prospective employer or an employer that runs a query, they're going to pay for it. But a driver can look at themselves at any time for no charge. Now, when the motor carrier came out and was presenting the clearinghouse information the last week of March at the National Drug and Alcohol Screening Association's annual conference, this was the biggest point of contention, was how do you require and force, come November to January, all of your current drivers to register into the database? How do you herd cats? Was kind of the question that we threw at them. Didn't really have an answer, except their only answer is it's required. Okay, so there's obviously provisions that would eliminate the ability for a driver to drive or get hired if they don't provide consent. But somehow they're also, they being FMCSA, they are requiring drivers to register into the clearinghouse. So we have yet to sort of understand how that's going to happen or how an employer is going to effectively encourage them. Drivers that are notified by FMCSA via US mail of any changes made into the clearinghouse, that might not happen at all if you're not registered, right? So if you're not registered, but you have a violation that was entered because you went and took a drug screen and it was a positive drug screen, they may not know how to reach you, but you're going to be in there, and eventually you're going to get caught. So some question marks that still loom over our heads.
And the cost, the get caught is, didn't you say the fine is what, $11,000?
The rumor has it, so don't hold me to it because I haven't seen it in writing. Right. But the rumor has it that there's roughly a $10,000 per occurrence fine for non-compliance. Now, I don't know if that's just employer and service agent or if that also could point to the driver. I don't know that answer.
Or an operator who's both.
I fully expect the service agents could see those types of fines, the employer for sure. Right. Just not 100% on the driver, so more to come on that. See, I'm setting myself up so that you have to have me back.
Yes, ma'am. You've already sold me on that.
Drivers may challenge any of the information in the database for accuracy. So anybody that's familiar with running background checks, the biggest challenge that we run into and why we get litigated and sued all the time is based on accuracy. So it is the subject's full ability, and the law protects them, the consumer, the driver, the subject, to be able to get a copy of their report and look at it for accuracy. If what is in the database is not valid or not accurate, the driver can contest it. However, different than a background check, which the driver would contest it with the background check company, the driver has to actually go through an administrative process directly with the motor carrier. What that looks like at this point, I don't know. But that's what's written within the regulations. They will go through a review process at the motor carrier and look at accuracy that's been reported in. So it could be that obviously an employer can make mistakes, human make mistakes, putting information in, things like that. The only thing that they won't be able to do is the validity of a test result, because you got science behind you for lab testing and that. So they couldn't overturn a verified positive, but they could look at other things for accuracy, yet having to define it or go through an administrative process to do so. Now, violations remain in the clearinghouse for 5 years or until a return to duty process through the SAP program is completed.
Well,
Once they've completed all their follow-up testing,
Gina, what we're saying here,
I'm sorry, what?
No, what we're saying here then, if they don't go through the return to drive process, they're not be able to drive for 5 years?
Well, they won't be able to drive at all because the state driver's license agency is going to take back their CDL. But for 5 years, they're also going to be listed in the clearinghouse, so it's going to be really hard for them to get a job.
Yeah, even
Not
once.
twofold, right? There's a couple things there. So yeah, that'll make it impossible for them to get hired somewhere. But keep in mind that CDL will not be active.
But the other problem, this to make things even worse, and Rich, I appreciate this, is if they go through that process and then aren't be able to be rehired by somebody else because of other things, you might end up with an employee practice liability suit on that side of it.
It's possible. I just don't know how far anybody.
Yeah, I mean, I could see that. I could see that being attacked that way. So anyway, it's going to be interesting. Go ahead. I'm sorry, I didn't mean to interrupt you. I just keep us awake.
So, from a confidential perspective, and like we're kind of talking about driver information being entered in the database, CDL numbers and state of issuance are the only identifier. Social Security numbers are not going to be allowed in there. So I want to walk you through a process really quick, like to think through this, because you guys may not know, you're not going to know all these details that I fight with every single day. Since 1996, and since the collections process that we go through for training and qualifying to be certified collectors for the DOT or qualified directors for the DOT, it has always been trained that the collector is going to ask for a Social Security number, possibly an employer ID. They are not trained to typically ask for a driver's license number and state of issuance to write on that testing form. So to undo this behavior is going to be impossible because we got people out there who have been doing this for 35, 40 years. What that means is that testing form and that sample is going to go to the lab with probably a Social Security number on it. Then it's going to go to the MRO, who's going to match it up and produce a final result with a Social Security number. Then they're going to have to come either contact the driver, contact the employer, contact the third-party administrator to try and locate that driver's license and state of issuance in order to put that on the drug test itself. Whether it's positive or negative doesn't matter. We've now got a whole thing where we've got to be chasing down this information, and that's only motor carrier. It doesn't apply to aviation or railroad or Coast Guard or anything like that. You're asking people who collect P for a living, who make $15 an hour tops, to suddenly go, he's a driver under motor carrier. I now have to ask for this instead of this. It isn't going to happen. So we fully expect all of these fields are going to come back, and it's going to be, just hairy until a whole new line of training has been adopted and the behavior's been changed. It's critical because we don't want Social Security numbers out there, but just keep in mind that that's been the training for so long. That's where some of our costs increase. I anticipate we're going to go up. And then finally, Mexican and Canadian employers, drivers, and service agents that do business in the U.S. must comply with the clearinghouse. They don't have a choice. So they get to understand and know how to do this and put all their information in the system. Okay. Any questions with you guys?
Is that it?
No. So we're going to talk about privacy. So I've kind of mentioned this already. This is where the hair on the back of my neck likes to raise, because I am a consumer reporting agency, which means I get access to people's background checks. And what I pass through, I have to be incredibly careful of because I don't want to get sued. And this is a very sue-happy industry, if you will. Drug and alcohol TPAs don't have the same level of litigiousness as a background check company. Now, what this means for this is a whole potential niche of litigation, because in the regulations they stipulate that the driver's confidential, private, personal information that's warehoused in this database is also protected behind the Privacy Act of '74 and the Fair Credit Reporting Act. This brings a whole new element of holy buckets into this realm of information and who gets access to it and where does it go. The Privacy Act of '74 literally outlines, and this was initially for the credit agencies that were going after, you know, getting background on people's credit. It specifically tells how they can collect it, maintain it, use it, and disseminate it of the subject's information, and that written consent by the subject before disclosure of information must be obtained. And the individual has the right to their information at any time. So anytime you guys go and, you know, apply for credit and something comes back wonky, you have the right to get access to that in full and go and make amendments or corrections if it's inaccurate. Now, to take one step further, when we talk about Fair Credit Reporting Act, this was a legislation that was passed specifically to promote accuracy, fairness, and privacy of consumer information. So this is not only credit check, which is kind of what the Privacy Act started for, but Fair Credit Reporting Act also doubles for, but also workplace or employment consumer reporting. So that said, this will become a whole new arena for employers who potentially hire a third-party administrator that is not also a consumer reporting agency. This will put them in a whole new bucket for potential litigation. I spent about an hour and a half this morning on the phone with my attorneys that are experts in FCRA. That's the only thing I have hired her to do. I have other attorneys for other reasons, but this is the one thing she works on. And we're going to be doing a lot of due diligence and research on this, so I'm going to bring this more back to you, but this is a big deal that I want to highlight, because this could go off the rails in terms of employers and the third-party administrators that they hire. My one comment and my one takeaway is this: because you're accessing essentially private information that is protected by these two acts, employers really should be very cautious about who they engage in to do this on their behalf. And if their TPA is not also a full CRA that's insured and binded, and we're regulated, by the way, and I get audits by the big three, TransUnion, Equifax, and the like, they should proceed with caution and be very careful. So again, a good reason why we're starting early to have these conversations, because you insurance people, if you're also insuring for professional and general liabilities on your clients, this could be a whole other package that we need to talk about, or how you need to think about when it comes to an employer that potentially could get thrown into a class action suit of sorts based on TPA's actions.
Gina, two things. This falls under employee practice liability, which is an unsold product. But everything she just said, folks, also involves us as insurance industry cannot send NVRs to our insureds either, for the same reason she just went through. So yes. when I said in front of an audience, you mean, and they say you can't do it, this is the why.
Can't do it. No,
this is the why.
The other thing that will pose a question here is, what about adverse hiring and adverse action process?
Right.
In the background check world, that's part of the Fair Credit Reporting Act. Right. This is very definitively defined, but there's a very loose definement now that this has been included in with the clearinghouse as part of the governing agency or body. This makes it very challenging for an employer that runs a full query on a prospective driver that comes back with a violation, and how do you adverse hire? To be honest with you, this is also part of the research that we're going to be doing, and hopefully bringing some questions forward and maybe some recommendations, because your consent forms, your authorization forms may look different. And if you're running background checks anyway, good for you. You should probably, to ensure that you have clean hires that aren't bringing a bunch of nonsense into your business. But you can't just add a bunch of additional information that includes the clearinghouse without really being thoughtful and ensuring that you're not violating the FCRA when you do that, and you're still covering yourself with clearinghouse consent. So it's the beginning and adverse hire process that we're going to bring more on for you guys. But just keep in mind, when you're talking to your employers out there, and those employers that are on the line right now, if you're engaged with the TPA or thinking about it, because I think it's still a good idea to help offload some of this administrative burden, really think about, or start asking questions, and we'll educate more further on this down the road, whether or not they should have access to driver information when they're not a consumer reporting agent. Okay, that's a lot of stuff. That brings me to the summary. You guys still awake?
We're here.
Are you drinking heavily? So,
well, I'm going home and drink.
You got our head spinning.
If I wasn't on the diet, but go ahead.
that's my goal, to head spin, and then you can call me later and I'll unravel it. So the
Right.
clearinghouse registration, just keep in mind, starts November 2019 for all employers, drivers, and service agents that are part of the drug and alcohol testing, federal drug and alcohol testing process. Just know also that the rule enforcement begins January 6th. That also means January 6th is when employers need to start running full queries for all new hires.
Yep.
Any positive information that might come through the lab to the MRO also starts keying that information in effective January 6th. So it hits everybody. Employers are required to run full queries on all new hires, enter violations effective January 6th. So I'm being redundant, but I'm impressing the importance. Employers are required to continue previous employer checks, which is that manual process I mentioned earlier, until December 6th of 2023. So keep in mind, this is now becoming a dual process for our poor employers, but it's required. And keep those on hand. And then obviously too, owner operators must engage with a qualified consortium third-party administrator to maintain compliance effective January 6th, really, and preferably one like us that is a full consumer reporting agency and we're fully insured in case we get sued. So that helps our employers as well.
Wow.
I know.
Rich, no, we'll have to revisit and figure out how to digest this this part. But folks, again, here's some resources. You can download this PowerPoint later on our website. Listen to it. Take it to the insured. It's time to talk now. One of the things the foundation has always tried to do, and Rich and I've been doing it forever, is trying to keep everybody ahead of what's happening in the future. And this is a big part of it. Gina, we really appreciate you giving your time today. Rich, thank you for finding her, and you can say something in closing. I'm going to finish this. Gina, we'll have you back. We thank you.
Thanks.
You're great. Appreciate it.
Thank you so much. Appreciate it.
Again, thank you, Gina. This is making your head hurt. There's some great links here in that, sign up for her newsletter, stay in touch, via watching that, and as well as these others. We heard that EPLI is something that should be talked about, employment practices liability. You motor carriers, you heard it, credit reporting agency protection is critical to you. There's a host of other things in here. So fines and the reality of this coming along is really going to impact the trucking industry next year. So thanks again, Gina. Thanks for all who tuned in, and go ahead and close it up, Tommy.
All right, guys, we're done. We'll see you all next month. You all have a good month. Thank you.